We are back operating, and I believe Mr. Del Mastro has a motion.
I do, Madam Chair.
Sorry, Mr. Del Mastro, is that a point of order? Because Mr. Del Mastro has the floor to move his motion.
Yeah,
is it a point of order?
Yeah. Just wanted to make the notice of motion that I put on the order paper today.
It's been sent. That's not a point of order, and it's not a point of order. We'll put you on the speakers list. Mr. Del Mastro.
Thank you. Thank you, Madam Chairman. As I indicated at the last meeting, I have brought forward a motion which I'd like to move at this meeting and present to the members for their consideration. The motion is as follows, that the Standing Committee on Access to Information, Privacy and Ethics call Mr. Adam Carroll, former Liberal Research Bureau employee, for one meeting to examine his use of House of Commons resources in order to conceal his anonymous public attacks on a Member of Parliament, and that this meeting take place by Thursday, March 8th, 2012. I think it's important that we examine this. I think the use of House resources to specifically attack and conceal that attack on another member in good standing in the House of Commons is something that all parties should in fact deplore and something that all parties should in fact want to get to the bottom of. Thank you.
Thank you, Mr. Del Mastro, and I am going to make a ruling on the admissibility of the motion. I thank the honourable member for having moved his motion. However, I am of the opinion that as moved, the motion is inadmissible for the following reasons. I should note that although I recognize that the decisions taken in a different iteration of a same committee are not binding to a current committee, I would be remiss if I didn't restate for the benefit of the current members of the committee a decision made in a similar case in the last Parliament on March 7th, 2011 by the first Vice Chair, as I feel it answers many questions surrounding the admissibility of the motion now before us. First of all, I believe that the motion goes beyond the mandate of the committee, specifically with regard to Standing Order 108-3H6, which states, the proposing, promoting, monitoring, and assessing of initiatives which relate to the access to information and privacy across all sectors of Canadian society and to ethical standards relating to public office holders, and any other matter which the House shall from time to time refer to the Standing Committee. It is important to understand the definition of public office holders with regards to the mandate of the committee. This standing order refers to the definition as described in the Conflict of Interest Act 2006, which was cited in a previous ruling in this Parliament by my predecessor, Mr. Cullen, on September 27, 2011. Most importantly, however, the Parliament of Canada Act in Section 52.6.1 states that the Board of Internal Economy has the exclusive authority to determine whether any previous, current, or proposed use by a member of the House of Commons of any funds, goods, services, or premises made available to that member for carrying out of parliamentary functions is or was proper given the discharge of the parliamentary functions of the member of the House of Commons, including whether any such use is or was proper having regard to the intent and purpose of the bylaws made under Section 52.5.1. This is further emphasized on page 238 of the second edition of the House of Commons Procedure and Practice, O'Brien and Bosk, which goes on to say, the Board of Internal Economy determines the terms and conditions of managing and accounting for the funds by members and has exclusive authority to determine whether this use is or was proper. Other bylaws set out the terms governing members' use of their budgets and other benefits provided by the House, including travel points, printing privileges, staff, and the purchase of goods. As members of Parliament, the proper use of parliamentary resources is something that concerns all of us. However, I believe, for the reasons stated above, that this committee is not the proper forum in which to have this discussion. I assume you're challenging the ruling of the chair, Mr. Butt.
I am. As much as I have great respect for the chair, I just don't agree with the ruling. I think it's very important that this committee look into this issue and determine the extent of it, and I think it's an appropriate place for this committee to spend a little bit of time looking into, and therefore I will challenge the ruling of the chair.
That motion is not debatable. All in favor of all in favor of the motion. Point of order. Sorry, this is not debatable. A recorded vote.
Sorry.
Thank you. All in favor of the motion. Sorry. Sorry.
Just
yes,
on a point of
sorry.
clarification, Madam Chairman, are we voting in support of the motion to challenge the chair, or voting in support of the chair?
Because it's a recorded vote, the clerk will restate the question.
The question is, shall the ruling be sustained?
Okay, so our answer is no.
Okay. Mr. Butt? No. Mr. Calkins? No. Mr. Carmichael? No. Ms. Davidson?
No.
Mr. Del Mastro?
No.
Mr. Dreeshen? No. Mr. Mays? No. Mr. Angus?
Yes.
Monsieur Dussault?
Yes.
Monsieur Morin? Mr. Andrews?
So the ruling of the chair is overturned. We will now proceed to debate on the motion as presented by Mr. Del Mastro. And Mr. Andrews, I had you first on a list here.
Certainly, Madam Speaker. I think it's rather interesting that we have this motion before here today, and then your motion being overturned because the Conservative Party didn't get their own way in the committee once again. They used their parliamentary will and their numbers to overturn the chair just when they don't get their own way. And today it was very interesting that the Speaker of our House of Commons made a ruling on this very, very issue. And I would argue that now that the Speaker has ruled on this issue, the committee should not be debating it at all unless members of the Conservative Party would like to overturn and challenge the ruling of their own member in this very matter. So I think it's important that we look at the ruling of the with the ruling.
The Speaker's not a member of our caucus.
Excuse me. Mr. Andrews has the floor. Mr. Budd, unless you're raising a point of order. Mr. Andrews?
Point of order, Madam
Point
Chair.
of order, Mr. Calkins.
With the greatest of respect, Madam Chair, it is quite clear in the common practices of this House and in the House of Commons, and thereby extending out to any of the committees who are created as a matter of the standing orders from the House of Commons, that any reference to impugn the integrity of the Chair of the House of Commons is simply beyond reproach. And I would encourage the member opposite to make very clear that he wasn't intending to impugn the reputation
Point of order.
by the political affiliation of the Speaker of the House of
Point of
Commons, who was
order.
elected by all members of the House of Commons.
Thank you, Mr. Calkins. I'm going to go back to Mr. Andrews. A point of order, Mr. Angus.
Well, I just think I was listening to the honourable colleague. I think they're trying to twist the words and turn this into a political debate. So I don't think that that's a legitimate point of order, and I think we should allow the Speaker to continue.
I'm going to go back to Mr. Andrews. Mr. Andrews, continue, please.
I was no way impugning that I was disagreeing with the Speaker or over the ruling. I was simply pointing out that the Speaker has made a ruling, and it seems that the members of this committee would like to challenge the ruling of the Speaker. And that's what I'm hearing. That's what I'm seeing the Conservative members of this committee do, is to challenge the ruling of the Chair. And less than an hour ago, the Chair made a ruling, and a ruling on a question of privilege raised on February 27, 2012 by the Minister of their own party, the Minister of Public Safety, Mr. Taves, regarding cyber campaigns following the Minister's tabling of Bill C-30, an act to investigate the preventing of criminal Electronic Communications Act and to amend the Criminal Code and other acts. The Speaker, in his ruling, said he was now pleased to rule on the question of privilege raised on February 27th by the Minister of Public Safety regarding cyber campaigns following the introduction of the House by him, Bill C-30. I would like to thank the Minister for having raised these matters, as well as the Leader of the Government House of Commons, Mr. Van Loan, the Minister of Foreign Affairs, Mr. Beard, the Parliamentary Secretary to the Leader of the House of Commons, the Leader of the Official Opposition, House Leader, Mr. Comartin, the Member for Toronto Centre, the Member for Bras-Richard, Nicolette Becantor, the Member for Saanich Gulf Islands, and the Member for Westmount Ville-Marie for their interventions. The Speaker went on to say, in raising his question of privilege, the Minister raised three issues, each of which he believed to be a contempt of the House. The first concerned the use of the House resources in the so-called WikiLeaks 30 account on Twitter, which was claimed was used to attack him personally, thereby degrading his reputation and obstructing him from carrying out his duties as a Member of Parliament. The interim leader of the Liberal Party then rose to inform the House that he himself had intended to rise on this question of privilege. Having been informed on February 26 that this was an employee of the Liberal Research Bureau who had been responsible for the WikiLeaks 30 site, the interim leader offered his unequivocal apology and that of the Liberal Party to the minister. In the view of this unequivocal apology made personally by the member on behalf of his whole party, and in keeping with what has been done in similar circumstances in the past, I'm prepared to consider the particular aspect of question of privilege is closed, over with. I also wish to inform the House that the use of Commons policy on acceptable use of information technology resources was applied in this case, and given this unacceptable use of House resources occurred. The minister also raised the matter of a apparent campaign inundated to his office with calls, emails, and faxes. This, he contended, hindered himself and his staff from serving his constituents and prevents constituents with legitimate needs by contacting the Member of Parliament in a timely fashion. As the member for Windsor-Tecumseh reminded the House, my predecessor, Speaker Milliken, has faced with similar situation in 2005 in a matter raised by the former member of Glengarry Prescott Russell. In his ruling on June 8, 2005, Speaker Milliken concluded that a member had a legitimate grievance that the normal functioning of parliamentary offices has been affected. The members involved and their constituents had still maintained the ability to communicate through several means. Thus, he could not find it was a prima facie case of privilege, as the members were not impeded in their ability to perform parliamentary duties. Having reviewed the facts of the current case, I must draw the same conclusion on this second aspect of the question of privilege. This brings to the third, which I consider the most troubling issue raised by a question of privilege, that of the videos posted on the website YouTube by the so-called Anonymous on February 18th, 22nd, 25th. These videos contain various allegations about the minister's private life and made specific and disturbing threats. The minister has stated that he accepts that coping with the vigorous debate and sometimes overheated rhetoric as part of the job of a politician, but argued that these online attacks directed to both him and his family have crossed the line into threatening behavior and was unacceptable. He contended that the threatening actions contained with these videos constitute a deliberate attempt to intimidate him with respect to his proceedings in Parliament. In the House of Commons Procedure and Practice, second edition, it states, quote, "It is impossible to codify all incidents which might be interpreted as a matter of obstruction, interference, molestation, or intimidation, and such constitute a prima facie case of privilege. However, some matters found to be prima facie include the damaging of a member's reputation, the usurpation of a title of the Member of Parliament, the intimidation of members and their staff and the witnesses before committee, and the provision of misleading information," unquote. In spite of the able arguments advanced by the member for Westmount Ville Marie, the Chair has no doubt that the House has full jurisdiction to decide over this matter. He noted on page 108 of O'Brien and Bross, quote, "Speakers have consistently upheld the right of the House and services of its members free from intimidation, obstruction, and interference. Speaker Lamoureux stated in 1973 ruling that he has no hesitation in reaffirming the principle that parliamentary privileges includes the right of a member to discharge his responsibility as a member of the House free of threats and attempts at intimidation. Those who enter political life fully expect to be held accountable for their actions to their constituents and to those who are concerned with the issues and initiatives that they may have advocate. In a healthy democracy, vigorous debate on issues is encouraged. And in fact, these rules on procedures and House affairs are drafted to allow proponents and opponents to discuss in a respectful manner even the most difficult and sensitive of matters. However, when duly elected members are personally threatened, their work in Parliament, when introducing a bill, making statements, or casting a vote, the House must undertake this very seriously. As noted by the Parliamentary Secretary to the Leader of the Government in the House, threats or attempts to influence a member's actions are considered to be breaches of privilege. I have carefully reviewed the online videos in which the language does indeed constitute a threat to the Minister in particular, as well as all other members. These threats demonstrate a flagrant disregard for our traditions and subversive attack on the most fundamental privileges of our House. As your Speaker and the guardian of those privileges, I concluded that this action, the videos posted by the Internet by Anonymous, therefore constitutes a prima facie case, and I invite the Minister to move his motion. And the minister did move a motion to refer the matter to the proper committee, the House and Procedural Affairs Committee. So obviously, the Speaker has ruled on 3 aspects of this privilege. 1, 2, and this third one, and in his ruling, and I respect the Speaker's ruling in referring this to the House of Affairs Committee to look at the third aspect. But what we're debating here today is a motion by Mr. Del Mastro to go into the first one that's already been ruled on by our Speaker. So I find it very disturbing that a committee would try to take something like that on. And like I said, the Speaker has ruled on this. The committee has no authority into looking into this matter any further. The leader of the of the Liberal Party has apologized unequivocally for the actions of a staff person. I, as a former staff person, know what it's like to be a staff of a political minister. And sometimes you push the envelope and you step outside your bounds, and this is what happened here. And this particular staff person has done this, and we have apologized for that. And it was a heartfelt apology. And I like to quote the apology from the minister, from the member for Toronto Centre, when he said, I do not share many things with the Minister of Public Safety, but all the time, one thing I do share with him is the sense of longevity. One of the things that makes public life difficult when political attacks become personal. I've tried, not always succeeded, in my political life to make it very clear that the matters of personal and private conduct are not the subject of political attacks or political interference. And I concur with the leader of the Liberal Party when he said that. Life is somewhat very difficult in this place when you try to do your job and when things personal, political becomes personal. Getting back to the House of Commons standing orders categorically on this issue, and this matter has been ruled with, and this matter has been dealt with. Standing Order 10 states, the Speaker shall preserve order and decorum and shall decide questions of order. In deciding a point of order of practice, the Speaker shall state that standing order or any other authority applicable to this case.
I have a point of order, Mr. Del Mastro.
Thank you, Madam Chairman. Madam Chairman, as this member would well know and as the Chair knows, committees are in fact the master of their own destiny. I don't see any relevance of a ruling by the Speaker of the House of Commons in the House of Commons related to House of Commons function. Committees are the master of their own destiny. Perhaps you could relay that to the member. These are not relevant to the motion at hand. Thank you.
I'm going to allow Mr. Andrews to continue. I think he's attempting to lay a case for their position around why this shouldn't be considered. I'm going to allow him to continue.
Thank you, Madam Chair, and to the Parliamentary Secretary, the Prime Minister. We'll get to that. We're quite. We know the rules regarding committees, and you like to select and choose which ones you like to use. So I'll get to that in a minute. The House of Commons Standing Order are categorical on this issue. Standing Order 10 states, the Speaker shall preserve order and decorum and shall decide questions of order. In deciding a point of order or practice, the Speaker shall state that the standing order or other authority applicable to the case. No debate shall be permitted in any such decision, and no such decision shall be subject to an appeal of the House. Furthermore, O'Brien and Bosch state the following on pages 1046 to 1047. The Speaker of the House is regularly asked to rule on the procedural admissibility of matters before the House. Rulings from the Speakers constitute precedents for future Speakers of the House. This matter before the House may pertain to the proceedings of one or more committees. If the Speaker rules on a matter of that nature, the committees affected will be required to comply with any provisions of that ruling. So we've just read the ruling out, and it's out of respect that we comply with the ruling of the Speaker that this question of privilege is now closed. The issue could be no clearer. The Speaker has ruled. We must comply. Anything else would be that we're contrary to the standing order and we're challenging the ruling of the Speaker. O'Brien and Bosch is very clear where committees derive their authority, and that is from the House itself. On page 973, they state the following. The House delegates certain powers to the committee. It creates an order that they can carry out their duties and fulfill their mandates. Committees have no power other than those delegated to them in this way and cannot assume other powers on their own initiative. Committees can invoke these powers with only and for the purposes of the mandate that the House has entrusted them. On page 1044 states the following: the committee procedures includes all the rules and practices governing the proceedings of parliamentary committees. The primary sources are the Constitution and Acts of Parliament, orders of reference, instructions of standing orders of the House of Commons, rulings by the Speaker of the House of Commons and committee chairs, and finally, practice. For the sake of emphasis, I'd like to repeat: the primary source are the Constitution and Acts of Parliament, orders of reference, instructions, and standing orders of the House of Commons, and rulings by the Speaker. O'Brien and Bosch also states the following on pages 1047 to 1048. The idea that committees are the masters of their own proceedings or the masters of their procedures is frequently invoked in committee debates or the House, as the Parliamentary Secretary of the Prime Minister just referred to. The concept refers to the freedoms of committees normally have.
Could you read a little slower, because I don't believe the interpreters have a copy of this, and so they're having trouble keeping up. So just a little slower, please.
I'm sorry, Madam Chair. That's my Newfoundland dialect comes up when I sort of get all excited. Words come a little quicker than normal, so I'll try to slow it down. O'Brien and Bosch also stated the following on pages 1047 and 1048. The idea that committees are the master of their proceedings or the master of their procedure is frequently invoked in committee debates or the House. The concept refers to the freedom committees normally have to organize their work as they see fit, and the option of defining on their own certain rules and procedures that facilitate the proceedings, which is common with most committees, and we've done this regularly here. These freedoms are not, however, total or absolute. First, it's useful to bear in mind that committees are creatures of the House. This means they have no independent existence and are not permitted to take action unless they have been authorized or empowered to do so by the House of Commons. The freedom committees have is, in fact, a freedom limited on two levels. First, committees are free to organize their proceedings as they see fit, provided that their studies and the motions and reports that they adopt comply with the orders of reference and instructions issued by the House. Second, committees may adopt procedural rules to govern their proceedings, but only to the extent the House does not prescribe anything specific. At all times, directives from procedural sources higher than Parliament committees, Constitution, statutes, order of reference, instructions and standing orders of the House, and rulings by the Speaker take precedence over any rules a committee may adopt. This committee has specifically mandated it by the House of Commons. This is clear in Standing Order 108 in brackets H. The mandate involves the Access to Information Act, the Privacy Act, the Conflict of Interest Act. None of those acts apply to members of the House of Commons or their staff. An examination of a former House of Commons employee is beyond the scope or the authority of this committee given by the House of Commons. In light of all this, I would ask the Parliamentary Secretary to the Prime Minister a very important question. In the light of the Speaker's ruling, is he still really going to pursue with this motion? The answer to this question, if yes, then Mr. Damastro is voting non-confidence in our Speaker. The Parliamentary Secretary...
I need to intervene on that. I'm not sure that you can drag the Speaker into this in that way. The Speaker is neutral, selected by all members of the House, and a decision by the committee doesn't relate to the Speaker's role. So if you could proceed without drawing that inference.
Well, Madam Speaker, I think I just laid the case, Madam Chair, I just laid the case before this that an active directors from procedural sources higher than Parliament committees. We've already dealt with that. I've sort of laid that out. So I'm just trying to come full circle on this, Madam Chair.
My understanding is that the Speaker rules on a prima facie case and is not into the substance of the case itself. So he's made a ruling on the prima facie aspect of it, but it is now, I understand, if the motion passes tonight, being referred to Procedure and House Affairs for further investigation. So just on the anonymous piece. So I think in terms of getting into talking about non-confidence or confidence in the Speaker, that's actually not relevant. So if you could just continue with your argument.
With due respect, Madam Chair, that not this aspect of the ruling. The Speaker made the ruling on the aspect of the very motion that the Parliamentary Secretary is putting forward.
Point of order, Mr. Del Mastro.
The Speaker made a ruling on a question of privilege. The Speaker did not make a ruling on the motion before the committee. Thank you.
Yeah, the committee, again, as you know, I made a ruling on the mandate of this committee. It has been overturned by a majority of the members. The committee has decided with a majority of the members to proceed with the motion before us. So, you know, the committee has made a decision about the study it's choosing to undertake, and that's the matter that's before us at this point, not what the Speaker ruled or did not rule on. So if you could continue.
Madam Chair, it's hard to separate the through the weeds here on this. This is pretty specific. The motion relates directly to the Speaker's ruling. So the Parliamentary Secretary wants to ignore the ruling of the Speaker. This is just another attempt by the Conservative Party to draw attention away from the issue that is ongoing right now in the House of Commons and in the public domain of electoral fraud. And now they're trying to attack Parliament and try to attack the Speaker itself. Parliamentary Secretary, the Prime Minister, is saying the rules do not apply to him or the Conservative Party. They're bringing shame on themselves and throughout Parliament. I think that the apology was made. The apology was accepted by the Minister of your own party. Why can't you leave it at that, Mr. Del Mastro? Why do you have to go dragging before a committee a staff person of the Liberal Party who is sorry for his actions? The matter has been dealt with. This is just an attempt to discredit this particular individual, and he's lost his job, and that is hard enough on a family. So I don't think we live in a place here in Parliament that deals with this kind of stuff, and we're dealing with people's lives and families, and the very matter which at heart that we apologize for dealt with that. So there's really no need to carry that on. And I am saddened that the Parliamentary Secretary, the Prime Minister, would continue in this vein.
Thank you, Mr. Andrews. Mrs. Davidson.
Thanks very much, Madam Chair. I have a couple of things. I would, first of all, if I might, I would like to ask a clarification from the clerk, and then I'd like to propose a friendly amendment. The clarification first. If, in fact, this motion does proceed and passes, does it get treated under the rules of the routine proceedings? Is it like a 10-minute presentation and then there's the set rotation for questions? It's
a study that the committee would be undertaking.
So it would fall under the same rules. Okay.
That's right.
Thanks very much for that clarification. And if I could, I'd like to propose a friendly amendment deleting the last words Thursday, March the 8th, and replacing them with Tuesday, March the 13th.
So we have an amendment.
Just see if it's friendly. If the mover accepts
The mover accepts the motion, so we're now dealing with the amendment on.
the amendment's accepted.
The amendment's accepted? Okay. So that's accepted.
Thank you very much.
Are you done, Mrs. Davidson?
Yes, I am, thank you.
Mr. Dussault? Point of order, Mr. Andrews.
Are we now just debating? the-
No, it's
the amendment?
accepted because the mover of the motion agreed to the amendment proposed by Mrs. Davidson. So,
Thank you, Madam Chair. I'd also like to add a few words. For the past few days, we know that this isn't the right committee to deal with this matter. Whether we agree with this motion or not, this is in fact not the right committee to delve into this matter. And you said so, Madam Chair. As soon as Mr. De Mastro proposed the motion, unfortunately, the Conservatives opposed your position on this motion. And I would also add, because my colleague talked about the Speaker's ruling at the House of Commons, and I think it's also important to mention that the member for Provencher, the Minister of Public Security, Mr. Vic Tays, also presented a motion. He tabled a motion that will be voted on a little bit later because the vote was deferred to later. And the motion, I can read it in French and in English.
Intimidation of the honorable member for Provencher be referred to the Standing Committee on Procedure and House Affairs. Et en français, que la question des menaces, des entraves et de la...
The question of intimidation and threats for the honourable member of Provencher be referred to the Committee on House Affairs and Procedures. And it's the member for Provencher, the Minister of Public Security, asked that the whole issue of threats and intimidation be referred to this other committee. And when the videos were put online by Anonymous, and also the whole WikiLeaks matter, well, this was all part and parcel of the attempt to intimidate the honourable member for Provencher. So the motion before us, moved by the Conservatives, goes against the very motion that was tabled by one of their colleagues in the House this morning. And I find it a little bit strange to see them proceed with their motion. Perhaps they didn't speak to their colleague, the member for Provencher, about this motion, because he himself said that this matter should be referred to the House and Parliamentary Procedure Committee. So I think that if the colleagues had talked to their own colleague, they would have seen that this was the case, and they would have probably not gone ahead and tabled this motion because their colleague thinks that this isn't the proper committee. So I obviously support your position, Madam Chair, that this motion not be debated here because it's not the proper committee. And I find it a little bit strange to see how the members opposite are proceeding today. They are, in fact, hindering the work of the committee, and I do support that the proper committee be deal with this matter at hand. Thank you, Mr. Dussault. Mr. Angus.
Thank you, Madam Chair. I find it very distasteful that you see our committee being once again misused in this manner, and that your ruling as a chair is once again being overturned by the majority in the Conservative Party. The role of the Ethics Committee is a very specific and important function in the House of Commons. It is to look into and ensure for the Canadian public that the government is meeting its standards, its obligations, and that Crown corporations are meeting their standard obligations, that those who are under the Act, under ethics, under the privacy issue, under lobbying, are meeting their obligations. And that's what committees are called upon to do. What we've seen over this last session of Parliament, under the leadership of the Parliamentary Secretary to the Prime Minister, is an attempt to turn this committee into some manner of kangaroo court, where the role of the committee, the majority uses its power to investigate its political enemies. Now, there are many jurisdictions in the world where the power of the majority are used to investigate and go after political enemies, but in the Westminster tradition, we are not one of them. So,
Mr. De Mastro.
Thank you, Madam Chairman. I think the member would be well aware and well advised to research the history of this committee. In the 39th and 40th Parliament, he would see there's plenty of precedents as set by the opposition majority at that time for a study of this type. Thank you.
Yes.
Well, I don't think that was a point of order at all, but I actually think it actually underlines my case, which is that the role of the Ethics Committee is to hold government to account, not to hold former staffers in the third party and drag them before to trash their reputation. That is an overreach of this committee. But we've seen already a number of incidences where they've tried to turn this committee into a kangaroo court, and they've ended up looking rather ridiculous because they haven't thought this through. For example, my honourable colleague who wrote demanding an investigation into the New Democratic Party convention and then made all kinds of allegations about thousands of dollars of illegal money being changed hands, which I don't know if he said he saw or not, but the poor ethics commissioner was brought before us and the lobbying commissioner brought, and there was no evidence. This was just a complete smear. I hear him over there still demanding that he had evidence, but he didn't present it. And so you can make these accusations sitting around the table. You can trash people if you're the government, but then they never come through with any evidence, like yesterday in the House where they're now accusing the Liberal Party of suppressing their own vote. And I think, Madam Speaker, we saw the issue with the interference in the federal court where he tried to bring a judge before our committee, completely ignoring the standard limitations of parliamentary convention between the role of the courts and the role of Parliament, and said it didn't matter because he was the master of his own house. But of course that's not true. We saw them attempt to, again, overturn the Speaker and demand unredacted documents that were at the heart of a court case, a federal court case, a direct interference in the court case, and then they used the line that they were the masters of their own house so that they could abuse whatever privilege they were given under the limited mandate of this committee. And we saw the excellent legal review from Robert Walsh, who sent a real warning shot about the abuse of this committee by the Conservative Party and the attempt to undermine the long-standing sub judice convention, the long-standing limitations on the role of parliamentary committees to investigate but not interfere with the courts. But when it suited them, they felt that this was perfectly okay to be able to undermine the parliamentary tradition of this country to score a cheap political point. That's a staggering thing to do, Madam Speaker, when you're in government, because what we do here in Parliament is we establish precedent, very much like the court. So when you see a parliamentary secretary come in with whatever the latest hot-button government issue, their willingness to subvert the long-standing Westminster traditions that don't just affect Canada but actually have repercussions within the parliamentary traditions around the world. You see their willingness to actually shake the credibility and the foundations of how we carry our work out in Parliament for whatever cheap political purposes of the day. And now, the day, of course, the real issue is the issues of widespread electoral fraud that is rocking the country, and the Conservative Party are certainly scrambling to blame everybody else. I think they're now blaming Elections Canada for this electoral fraud scheme. So they need a game changer, and they've set upon a former staffer in the Liberal Party as an example that they will make, and they will drag him before here, and they will usurp the work of our committee in order to change the station on probably the most serious issue of electoral fraud in memory, at least as serious as the recent in-and-out electoral fraud, which we saw that the senior heads of the Conservative Party had to cop pleas on because they were busted and they were fully guilty and they knew it. And yet they're trying to divert our attention now on this issue of the so-called WikiLeaks. And I'm sort of astounded. I always give my colleagues more credit, perhaps, sometimes than they seem to be due. But I would have thought, in light of the Speaker's ruling this morning, which I thought was...
Point of order, Mr. Andrews.
Point of order, I just was wondering why the minister is now looking at apparently leaving the committee on his very own motion that he's discussing. He decides that this is not an appropriate time to share with us at committee his thoughts and dealings with this particular motion.
Sorry, Mr. Andrews, sorry, Mr. Andrews, sorry. Order,
Lane?
gentlemen, order. Mr. Andrews, I'm not sure that's a point of order. I'm going to come back to Mr. Angus.
Thank you. I think the issue that what we're dealing with here is the complete contempt they've shown for the Speaker's ruling this morning. And the Speaker's ruling is relevant because as much as Mr. Del Mastro thinks that this is his own personal court, that he can bring whatever witnesses and he can hang them however high he wants, we are subject and we are creatures of Parliament, and the highest order in our Parliament is our Speaker. And I've had enormous respect for the work that Mr. Scheer's done in this Parliament, setting a tone. And I think the ruling this morning, we need to really go through it carefully because I think it's very interesting. On the issue of Mr. Tave's claim that his right as a parliamentarian was interfered with because he had to put up with people calling him. Perhaps strikes me as the underlying contempt we see for the Conservatives for democracy, that the minister didn't like the fact that people were upset with a bill that intruded on the lives of average Canadians, that this was a bill, and this is where this all stems from, was this is Mr. Tave's personal bill to bring forward a legislation that would spy on average Canadians, and it caused a huge and justifiable storm of response from people who said, are you telling me that you think that you have the right to, number one, create these ad hoc inspectors to go in and demand documents from buildings without any warrant? Are you telling me that in the bill where the minister has the right to put whatever listening device he wants onto telecommunications to listen in? These are...
Madam Speaker, just we're drifting a little a ways away from the motion and the topic here, and falling into another personal attack against the minister, and this is what we're trying to find out, whether or not this was an unethical behavior of not only the person or the party. And I think if my honourable member would just stick to the motion, I think that would be acceptable.
So, Mr. Angus, if you could
Certainly, I think it's very important, though, because we are talking about what was ethical and what happened in the behavior, and I'm going to get to that. So, in the Speaker's ruling this morning, he said that this claim that having to listen to outraged constituents was somehow a breach of parliamentary privilege, of course that was absurd. So he took that aside. Then was the issue of the so-called WikiLeaks, and I have to admit I've never read a single one of these WikiLeaks, and I will get to WikiLeaks in a moment, but it seemed that he took the standard parliamentary response, which is that, well, in the old days they would have called us gentlemen, but now fortunately we have many more women involved, and it's made us a better place, but that there was this gentleman's agreement that when you apologize for your actions, that was sufficient. And that the Speaker said the Liberal leader had apologized for the action of one of his staffers. And so he felt that the issue should be dropped. But, of course, that doesn't fit the Conservative frame where they're trying to divert attention from electoral fraud. So they want to beat this up into the ground. But the third part of his ruling, which he handed over to House and Procedures Committee, was on the issue of anonymous. And I think this is very interesting. What makes the anonymous video worthy of investigation is the issue of threat. That you either change what you're doing, or we will embarrass you, or we will reveal documents about you. That is a direct interference with the right of a parliamentarian. And that is a serious interference, because we've seen since Parliament began the issue of protecting the privilege of the Member of Parliament to carry out their work. Now, in terms of Twitter and WikiLeaks, we're moving into all kinds of uncharted territories, and there are perhaps dangerous precedents the Conservatives may be attempting to intervene with in order to change the channel on the electoral fraud. In the world of Twitter, everything's anonymous. So I receive messages all day. Some of them are ugly. Some of them are hateful. When I speak up for First Nations, I regularly receive hate mail from anonymous people. I guess I could find out who they were if I looked hard enough, but they tell me they hate me. They think I'm a liar. They think First Nation people should freeze to death in the cold. I've received those. Now, that's Twitter. It's a different world. Now, if someone called me at home and said that, I might consider calling the police because I'm being interfered with. But in the world of Twitter, anonymity is part of it. But what we're seeing here is the issue of treating Twitter feeds the same as the anonymous leaks, which is different. The anonymous is a direct threat. You change this or we will punish you. Whereas in Twitter, people can write to me and say, I hate you. They can twist my words. They can take what I said in the House and they can mix it all up. And I guess if I was thin-skinned, I could go after them. Or they can actually say things that are true. And that's another issue. I have not looked at the Twitter feed at all on WikiLeaks. I'm not interested in the personal affairs of Mr. Taves. But the issue of ethical behavior here is then it becomes a question which I feel our committee is going to have to determine, were these claims true or false? Because this is a different issue. If Twitter is being used to libel someone, if Twitter is making things up about someone's personal life, then that is certainly an abuse of privilege. So as we go forward, the last thing I want to do is spend my weekend getting caught up on the WikiLeaks feed. But I think the Conservatives need to understand, if we're talking about what is ethical in Twitter and what's not, the fundamental question is whether or not it's true. Was this staffer making these allegations up? Is there validation in court documents? Is this something that will be verifiable? Because I certainly expect that if we are going to start charging people on Twitter who make fun of us, we're creating a dangerous precedent. And I'm certainly more than willing to take my lumps from whatever Twitterati are out there who can say whatever they want about me. But if they're saying a libel, well, then that's a different story. So the question of the WikiLeaks question, I think it's very distasteful that we're being asked to adjudicate on this, but we are going to be needing to ascertain whether this WikiLeaks feed was truthful or whether it was made up, whether it's verifiable or whether it wasn't. If it's verifiable, then it's a whole different issue than whether this was some allegation that was or smear. And, I think the Conservatives are desperate to change the issue of electoral fraud, but I don't think it's fair that they put one of their own ministers out in the limelight like this and turn the light back on them and say, we are now going to look at the WikiLeaks. We're going to find out what was in it. We're going to find out what was said. I think that exposes all manner of people to a more degraded system. But that seems to be where they're willing to use our committee. Rather than us addressing issues of the Ethics Act, many of the stuff we could be updating on privacy, we're now going to be focusing on someone with a BlackBerry, with apparently a court document, retyping it out into the public realm. And what does that mean for Parliament? I don't think we're going to be able to ascertain at the end of the day that someone who has a copy of a court document who releases it publicly has committed a crime. But it's certainly embarrassing, and it's certainly difficult, and that is part of the issues that we face as parliamentarians, is sometimes what's personal and what's private does get out there. And it is distasteful, and we've seen parliamentarians use it in the past, attempts to embarrass elected ministers because of their personal life. I would think that our committee is not one where we should be going there, but obviously this is a government that thinks very differently than me. I'm concerned, Madam Speaker, that this government is also setting up two really cynical standards. And we go back to the issue of the role of the committee to hold government accountable. So when we see political staffers interfering in the work of ministries, when we see political staffers trying to deep six information that citizens have a right to obtain, that is within the purview of our committee because that is interfering with the work of government, and that's where our committee has a right to ask and find out. But the Conservative Party told us that all their staffers are protected, that this was unacceptable, that their staffers would be brought forward to explain their actions in interfering with the public's right to know, or their monkey wrenching with the public service, that they have shielded their staffers around a cloak so that the political staffers within a various departments may be able to do anything. And yet the Ethics Committee would not be able to ask them a single question because we'll send Minister John Baird, and he said the buck stops with me. But now, when it comes to a former member of the Liberal caucus staff who sends out some Twitter messages, the Conservative Party is taking a completely different point of view, which is we are going to use the power of our majority to go after a staffer in the third party on something that has absolutely nothing to do with the workings of government.
Point of order. Point of order, Mr. Butt. Well, Madam Chairman, I don't think the member has read the motion because this motion is about the use of House of Commons resources. That's what the committee, that's what the motion is for the committee to investigate. Not all this other wild, crazy stuff. It is one meeting, one individual where we're asking him to come forward to talk about his use of House of Commons resources in this issue. It is very clear what it is, and I would wish the member would speak to this motion and not all the theatrics of all the other nonsense that he's been spewing.
Point of order.
Sorry, Mr. Butt, I assume your point of order was on relevance?
Yeah.
Correct. So, Mr. Angus, if you could speak to the motion, it is about the use of House of Commons resources.
Yes, and I'm going to reiterate because my friend perhaps didn't understand, so I don't want him to leave this house this room not fully understanding. So I'll reiterate for him that when the Conservative staffers were interfering, political staffers were interfering with the work of the civil service, that's an interference in the work of government. And yet the Conservative Party took the position that their staffers were protected, that it was completely unacceptable for members of Parliament to investigate any staffers working in a minister's office who may or may not have interfered with the workings of the civil service and the workings with the rights of Canadians to ensure the government is accountable. So they have created this firewall around their own political staffers, and yet they want to know, did he use a BlackBerry, the Liberal staffer, did he use a BlackBerry, or did he use a computer on the Hill to come out with the WikiLeaks? What I'm saying is that there's a complete double standard here, and the member may be interested in whether it was a House of Commons computer or a BlackBerry. I'm interested, and the only reason that if this is going to go forward, the issue for me is the attempt of this committee to go after people on Twitter because they don't like them. It's whether or not this government is going to be interfering with people who embarrass you on Twitter. So if the government wants to bring forward this motion, then I am going to find out whether what was said on WikiLeaks, was it true or was it false? Is it verifiable? Is there data to back it up? Because this is the fundamental issue here, that the government can start deciding to find out who in the House of Commons has a Twitter account and go after them. What is disturbing about WikiLeaks is that it was all about the personal life of a minister, again, which I've never read. But if the government decides that they're going down this route, then it is perfectly fair within the work of this committee to ascertain whether those statements were true or false, not whether it was done on a House of Commons computer or done at home. The issue is the role of a Twitter account, which again, and I don't want them to come out of here confused. There's a difference between Twitter and comments on Twitter and sarcastic comments and twisting words on Twitter and what happened with Anonymous. And this is why I think the Speaker made a fundamentally just ruling. The issue with Anonymous was that you will withdraw this bill or else. You will change your course as a member of Parliament or else we will embarrass you. That is an interference in the rights of a parliamentarian. That is an interference in the work of this House of Commons. We can never be intimidated when we go in to vote. This goes back to Laurier almost being kicked out of the church. They could not interfere with his right to represent his constituents. That is different than what we're talking about with Twitter. and whether or not people on Twitter are making comments, whether they're misrepresenting or whether they're telling the truth. So if the government is going to start to go after a Twitter account because it's from someone that they don't politically like, then the issue for me is what was said on that Twitter account. Is it true? Is it verifiable? If it's false, then it's actionable. But if it's true, then you know what? That's just the unfortunate reality of a world in the anonymous Twitter age. And I think that as parliamentarians, we have to be very, very, very circumspect about going down a road where we will decide to start investigating people who have Twitter accounts in the House of Commons. So to reiterate, Madam Speaker, because I see my colleagues there are still, I'm not sure if they fully get the implications of what they've just asked for. They want to go after the Liberal staffer, the former staffer, who's lost his job. And, you know, again, this is quite a punishment to take for someone who thought perhaps he was just engaging in the political discourse of the day, that he'll be brought before this committee and investigated for the fact that he used a computer. I find this absolutely bizarre. I find this is a disrespect to our work as parliamentarians. It's a disrespect to the minister who, even though he did have a rather thin skin when it came to the fact that he didn't like hearing from constituents who didn't like his bill and thought that was a point of privilege, at least the Speaker ruled carefully. But, Madam Chair, you ruled very carefully and judiciously this morning, and they ignored it. I think that what we're seeing is that the role of Parliament has to respect certain conventions. And if it doesn't respect those conventions, then it turns into the law of the jungle. And that seems to be what this committee has been doing again and again and again under the parliamentary secretary. So if the government brings this forward, then we are going to have to look at the veracity of the Twitter feed and what was said and whether it was true and what kind of documents back up the claims that were made on WikiLeaks.
Thank you, Mr. Angus. Mr. Andrews?
I'd like to amend propose a little friendly amendment to the motion. That the Standing Committee on Access to Information, Privacy and Ethics call Mr. Adam Carroll, former Liberal Research Bureau employee, for the one meeting to examine his use of House resources in order to conceal his anonymous public attacks on a member of Parliament, and the committee examine all government resources used on Twitter accounts, and that this meeting take place by Thursday, March 8th, 2012. So I think it's a little friendly amendment.
Can you repeat that again, Mr. Andrews?
Yep, certainly.
Clerk?
That the Standing Committee on Access to Information, Privacy and Ethics call Mr. Adam Carroll, former Liberal Research Bureau employee, for one meeting to examine his use of House of Commons resources in order to conceal his anonymous public attacks on a member of Parliament, and insert, the committee examine all government resources used on Twitter accounts, and that this meeting take place by Thursday, March 8th, 2012. So it's a friendly amendment.
In the absence of the mover of the original motion, I will say that motion would not likely be accepted by the mover, and so it will be on the floor for debate. So we are now debating your proposed amendment, Mr. Andrews.
Well, Madam Speaker, the mover of the motion isn't here. I think you...
So I have to assume that Mr. Calkins on a point of order.
Madam Chair, I take a little bit of umbrage with the fact that you've made a decision on behalf of a member, present or otherwise. The reality is, in the standing orders and the rules and procedures of this place, there is no such thing as a friendly amendment. So if the honourable member across the floor wishes to propose an amendment to the motion, then he should be proposing an amendment. He's simply playing games, childish games, which is, we've seen these kinds of things from time to time. But the reality is, he either means his amendment, wants to propose it and debate it and discuss it before this committee, or he doesn't. And Madam Chair, I would be remiss in my duties as a member of Parliament to think that should I not, as a regular member, not be at this committee someday and somebody were here in my stead, that you would take a decision on my behalf if I wasn't here. I'm a little bit concerned with your comment.
Mr. Calkins, I wasn't taking a decision on behalf of the member, but in the absence of the member, that this motion will now be debated because there is not an ability for the member to provide consent to the amendment. And I would actually require... I would require unanimous consent in order to accept that motion. And so on Mr. Andrews' motion, do I have unanimous consent to agree to Mr. Andrews' motion? No. Mr. Andrews, continue with debate.
Madam Chair, I would argue that we probably should suspend the committee until the mover of the motion returns to see if this is friendly or not. And to Mr. Calkin's point of order, I'd just like to refresh his memory from about 25 minutes ago when we had a friendly amendment from Mrs.
Mr. Andrews, if I could interrupt, I erred on that. I should have sought unanimous consent from the committee to agree to that change in debate. There actually, Mr. Calkins is quite correct. There is no such thing as a friendly amendment. I apologize that the clerk has informed me that that decision could have gone to debate on the date, but we moved beyond that. So there is no such thing as a friendly amendment. So proceed on your motion to amend.
Well, I'd like to get back to, since we didn't have an opportunity to debate Mrs. Davison's motion on pushing this out till March 16th once again, I'd like to come back to that because we didn't have an opportunity to even debate that because we just thought it was a friendly amendment, and one could do friendly amendments to motions and carry on. So I'm a little bit confused here, Madam Chair.
So, Mr. Andrews, given that nobody challenged my acceptance of that amendment, that has now been decided. So I now have your motion to amend the amended motion of Mr. Del Mastro on the floor so we can debate your amendment that's before us.
Okay. I'll come back to the amendment by Mrs. Davison afterwards, but it gets to the point of what government resources are being used for Twitter. This is just not a House of Commons resources that are being used for government business. We've got government members over there on their BlackBerries as we speak, putting off tweets. Tweets are being used all over the place for government business as such.
Point of order. I'm just curious of what I see. No one over here that is putting out tweets, and a comment like that I think is completely unnecessary.
Unsubstantiated, just like everything else coming out.
Mr. Andrews, if you could continue with your
thank you very much.
comments on your
Quite
motion,
often,
and perhaps not make inferences.
Okay. Often when I'm in the House of Commons during question period, I see the Minister of Industry quite frequently using his BlackBerry to tweet unsubstantiated claims and rhetoric, and he's using government resources at that particular time to put out tweets. I'd like to ask Mr. Mays. I don't find this very silly at all. What I find silly.
Gentlemen, I have a speakers list. If you wish to be on the list, please signal to the clerk you wish to be on the speakers list. Mr. Andrews.
It's funny how some things are regarded as silly, and but when they put motions like this, they're not very silly. So we'll take this very seriously. We're talking about government resources, House of Commons resources. And I have now wanted to, if you want to go down this road, let's talk about all government resources. Quite often, ministers, parliamentary staff, ministers, executive staff are using tweets on an ongoing basis to promote their minister. And often they take on attacks on members of parliament as well. And it was just recently I was attacked by a member of a minister's staff on Twitter, and I don't see me getting my knickers all in a knot regarding what he was saying. I found it quite interesting, though, and so did a lot of other people on Twitter, that he was doing it anonymously. He had not disclosed himself as a ministerial staffer out there. Contradicting and challenging a member of parliament over Twitter. So when someone uses Twitter anonymously, as the motion says, I think we need to look at the broader problem and the broader scope of this. and why ministers' offices often, on directive, have guys sitting down at computers all day long, putting out tweets on their minister, and then turning their resources on attacking a member of Parliament over this. So if the government members want to go down this very, very serious road, well, we need to look at it in-depthly on how rampant this particular issue is. Getting back to the amendment made by Ms. Davison a little while ago to push this out another week.
Point of order, Mrs. Davidson.
Yes, I believe that we're debating another amendment. We're not debating an amendment that was accepted and has been over with for quite some time.
Thank you, Mrs. Davidson. If you could stick to the amendment before the committee, Mr. Andrews.
Actually, I'm wondering, maybe we could talk about this, because when I read out my amendment twice, I think I used both dates, March 8th and March 16th, so I wonder if the clerk could clarify which one I actually said, since we now want to talk about the date of the appearance.
The date in the motion is the 13th.
The date in the motion is the 13th, Mr. Andrews.
So, okay, yes, that was the amended motion.
Yeah.
Okay, well, since we're talking about the amended motion, I'd like to talk about this date as well.
We're talking about your amendment, and your amendment used the date of March the 13th. So if you can proceed with your amendment to the motion.
And that date was put forward by Mrs. Davison.
That's correct.
Thank you. So that date now, they instead of calling this week to deal with this, they want to push this out next week. Obviously, they're trying to get as much legs under this story as quite possible.
Davidson.
Madam Chair, with all due respect, he is not debating his amendment that he has on the table, and I would request that you ask him to go back to his own amendment. Thank you.
Thank you, Mrs. Davidson. Mr. Andrews, if you could come back to the date has been dealt with. If you could come back to your proposed amendment.
The date in my amendment?
Committee examine.
Yeah, the clerk is pointing out that your motion was that it added those additional words around the government resources being used. I don't have the exact wording right in front of me, but it was not about the date. So your motion was about these additional resources that the government was using on these accounts.
Okay, fair enough. I'll park that and come back to that when we get back to debating the motion as a whole. So, Twitterati, as one of the commentators back home calls them. Quite often, he refers to them in his preamble into his talk show host, that the Twitterati out there quite often refer to different matters of public discourse and public commentary. So, is it acceptable for any government employee to use Twitter and the use of this resource to attack a member of Parliament or another member? This is something that we should look at. Quite often in business places, they block the use of social media so their employees can't use that mean of communication. So I'm kind of curious now whether we should broaden the scope here and really look into how we use Twitter. And I'll go back to that employee that I mentioned a little earlier, using government resources to challenge a member of Parliament. And his name was Corey Han. He's the Minister of Intergovernmental Affairs, President of the Queen's Privy Council, Press Secretary. And he's got a nice picture of himself there on Twitter, looking at his government desk. I can see the Parliament of Canada calendar in the background. He has not only one BlackBerry, but he's got two BlackBerries to use his Twitter account. And I had made a comment on Twitter myself during a debate in the House of Commons when I saw the minister responsible for Newfoundland and Labrador the Minister of Fisheries and Oceans. I was on the back as he was sitting down in the House of Commons for what a great answer he gave regarding the death of a boy in Labrador and the use of government resources that didn't help save that young person's life. So I put out a tweet that I couldn't believe that the Minister for Newfoundland and Labrador would do such a thing on Twitter, and it gained a lot of attention, and then
You're making an unsubstantiated claim. Could you read that Twitter line out so I know if I've read it or not?
Okay, I happen to have the whole dialogue that I had here that particular day, Madam Chair, and let me just go back here and see what I said. I said, oh yes, I said, wow, a Minister of the Crown is patting.
Point of order, Mrs. Davidson.
Yes. Could we please have the amendment reread, because I'm not sure that he's even debating his own amendment, and we don't have the wording.
Thank you, Mrs. Davidson. Mr. Andrews, at the request of a committee member, could you reread your amendment?
Don't lose the Twitter feed, though.
I got to come back to that.
Good.
I thought the clerk had my amendment, Madam Chair.
No, I didn't get it all now.
He didn't get it all?
But we know it didn't include the date, Mr. Andrews.
I know it actually includes two dates, because I'm pretty sure I read out both dates when I was asked to read this two times. That the standing...
Just read the amendment part. You don't need to read the whole motion, just the amendment part.
We're trying to be thorough here.
Okay, go ahead, Mr. Andrews.
That the Standing Committee on Access to Information, Privacy and Ethics call Mr. Adam Carroll, former Liberal Research Bureau employee, for one meeting to examine the use of House of Commons resources in order to conceal his anonymous public attack on a member of Parliament, comma, insert. The committee examine all government resources used on Twitter accounts, comma, and that this meeting take place, and this is where there's been some debate, because I think I said March 8th on one occasion, and then I said Tuesday, March 16th, and I don't even think March says 16th. This, I think it's actually the 14th. So we'll go along with whatever the date was that Mrs. Davison proposed for now.
Mr. Andrews, so if Mrs. Davidson, you raised a point of order about whether Mr. Andrews was actually debating his amendment. And Mr. Andrews, if you're going to make that link around all government resources in your current line of debate, that would be helpful.
Pardon me, Madam Chair?
Making the link in your current line of reasoning to your amended motion. Mrs. Davidson, was that a point of order?
I have a clarification on that amendment, if I might.
Go ahead.
I believe when Mr. Andrews read it out, he said, for one meeting to examine the use of House of Commons resources, and our motion reads his use. Is that word changed as well?
So, Mr. Andrews, on the third line of the motion where it says for one meeting to examine, you said the use, and the motion before it says his use. Were you changing his to the? There's no such thing as a friendly amendment, Mr. Calkins. I have a speaker clarifying with Mr. Andrews on your motion.
For the meeting to examine his use.
His use. So you were not changing his to the.
I'm just reading it out.
Okay, his use. So it was his use.
So then I would suggest that if the motion in fact refers to his use of House of Commons resources, then I think that we need to continue to make sure we're staying on track with the amendment.
My understanding is, I'm sorry, it's adding a completely different element to the motion. If Mr. Andrews, could you just read out your amendment, not the whole thing, just your amendment? That's
I can reread it.
Okay, I'll get the clerk to reread it.
So the amendment as it would appear in the minutes would read that the motion be amended by adding the words after Member of Parliament the following, comma, the committee examine all government resources used on Twitter accounts, comma.
So based on that amendment, Mrs. Davidson, I believe that I'm going to allow the member to continue because I believe he was making a link between some named staffer for one of the ministers. So, Mr. Andrews, continue.
Thank you, Madam Chair. And I was making a reference to how government resources are being used on Twitter, and the staffer that I named works for the Minister responsible for Newfoundland and Labrador. And my tweet that day, it happened on February 9th, to the question from one of my colleagues here. On February 9th at 3:09 p.m., I tweeted in the House after I got to one of the last questions in question period, "Wow, Minister Peter Panashwe pats Minister Atfield on the back after the question of the death of a boy from his riding and the lack of SAR, that stands for Search and Rescue, in Newfoundland and Labrador."
I'm going to interrupt at this point. We have run out of time. We will maintain the speakers list as we've got it before us. On Thursday, we will continue with the amendment on the floor by Mr. Andrews, and we also have another notice of motion. Meeting adjourned.